Chào mừng các bạn quay trở lại với chương trình ngày hôm nay. Chúng ta sẽ nói về Crucial 1, ROM 1, ROM 2. Các bạn đã thường nghe nhắc đến những cái regulation rất nổi tiếng là Crucial 1, ROM 1 và ROM 2. Như vậy thì những cái quy định này của khung pháp luật châu Âu thì có ý nghĩa gì? Và chúng ta sẽ nghiên cứu như thế nào. Sau đây sẽ là phần trình bày của chúng tôi về the same fundamental principle, những quy tắc chính, những cái similar situation và structures coherent và cái interaction của tất cả những cái quy định này thì thể hiện như thế nào. So the first one is about the regulation 593/2008 European Parliament of the Council of 17 June 2008 on the applicable to contractual obligation. Như vậy người ta thường nói tới ROM 1, ROM 1 ấy, thì đó là cái regulation số 593/2008 của European Parliament và liên quan tới cái lĩnh vực là xác định cái luật áp dụng tới những cái quan hệ nghĩa vụ của hợp đồng. Đó, thì được gọi là ROM 1 năm 2008. Khi người ta nhắc đến ROM 2, đó là cái number 864/2007 of European Parliament of the Council of 11 July 2007 on the law applicable to non-contractual obligation. Như vậy cái ROM 2 thì người ta sẽ điều chỉnh những vấn đề ngoài hợp đồng liên quan đến tort law. Và tiếp theo đó là cái regulation 44/2001 of the Council of 22 December 2000 on jurisdiction and recognition and enforcement of judgment in civil and commercial matter, Crucial 1. Thì như vậy người ta nói đến cái regulation số 44/2001, thì cái đó là các bạn sẽ ngầm hiểu đó là cái ROM 1 và amended by regulation 1215/2012 of European Parliament and the Council of 12 December 2012. Thì năm 2012 đã có một cái regulation sửa đổi cái regulation 44. Như vậy người ta gọi là Crucial 1 bis. Crucial 1 bis. Thì ba cái này nó sẽ liên quan. Thế cái Crucial thì đó là liên quan tới cái việc công nhận và thi hành những cái phán quyết thuộc lĩnh vực dân sự và thương mại. Đúng không? Như vậy hai cái đầu thì liên quan đến luật áp dụng, và hai cái sau thì liên quan tới cái việc công nhận và thi hành những cái phán quyết này. Như vậy thì chúng ta thấy là trong cái private international law rất là quan trọng trong việc xác định cái luật áp dụng tới cái vấn đề tranh chấp. Và cái thứ hai đó là gì? Xác định cái việc mà thi hành và enforce, công nhận những cái judgment là như thế nào trong cái luật của châu Âu. Như vậy thì những cái này nó sẽ có tác dụng gì? Interaction của những cái ba cái regulation này sẽ có những tác dụng gì? Chúng ta sẽ cùng xem thêm nó sẽ có những cái tác dụng gì trên thực tế đây. The first one is create a uniform normative complex of private international law, civil and commercial obligation, and to complete itself. This could be characterized by the common concern to favor the predictable of law and judicial certainty within European legal space. All right. So the spec are expressly articulated by EU legislator at the recital 7 of the respective preamble of the ROM and ROM 1 and ROM 2 regulation demonstrate when the ROM 1, the substantive scope and the provision of this regulation should be consistent with the Council regulation number 44/2001 on judicial and recognition and enforcement of judgment in civil and commercial matter. So we call Crucial 1, and the regulation number 864/2007 of European Parliament and the Council on the law applicable to non-contractual obligation, Proposal 2. Rom 2, and then the substantive scope and provision of this regulation should consistent with the regulation 44,001 on jurisdiction and recognition and enforcement of judgment in civil and commercial matter. So we call Proposal 1, and instrument dealing with the law applicable to contractual obligation. So we can see here we have some common principle, the same fundamental principle. So all three regulations based on the same pillar of private international law, which are, the first one is the principle of freedom of choice. The second is the principle of proximity. And the third one is the principle of protection of a weaker party. So the first one, when we talk about freedom of choice, is a key in the field of contractual obligation. It takes precedence both in substantive law and in private international law, and private international law is essentially expressed by the liberty of the party to choose the applicable law. So very important, this one. And the recital 11 of the preamble to regulation Rom 1 ascribes to the freedom of the party to choose the applicable law of role, one of a cornerstone of legal system to conflict of law rules in matter of contractual obligation. And regulation Rom 2 dedicate Article 14 to party autonomy, but according to it less important than Rom 1. And this can be explained by the contractual matter as a result of the structure and obligation relationship resulting from this kind of obligation. In most cases, the party do not have a prior relationship. Rom 1, Rom 2 offer a similar limit on freedom of choice, so they contain parallel norms in the event of localization of the element of the situation in a single country or within the European Union. And they provide for the application of imperative rules of a legal system as per its international law, Article 3, 4 of Rom and Article 14 of Rom 2. The European imperative norm takes precedence in order to guarantee a minimum European standard of protection, Article 3, 4 of Rom and Article 14 of Rom 2. All right. So, for regulation incorporated in concept of overriding mandatory provision, Article 9 of Rom 1 and Article 16 of Rom 2. However, this concept defined only in regulation Rom 1. There's no object to use it also in regulation Rom 2. So regulation Brussels 1, this is based on the same principle when in this Article 25 provide for forum selection clauses. All right. So we can see that the three regulations are so similar. With respect to role, they accord to the principle of proximity, the principle of closest connection. So it could be described through example. On one hand, there's the role of the habitual resident or domicile, either as the principal criterion for the objective determination of the applicable law or as a territorial connection with litigation. And on the other hand, the regulation provides a escape clause in the event of others, more close connection. And in action of the choice of law made by the party, Article 4 of regulation Rom 1 is based on the habitual resident of the party whose performance characterizes the contract, and criterion prevail over that of the place of the performance of the obligation, which have given rise to some controversy in the context of Article 5, 1 Proposal 1, Article 7 of Proposal 1. This very, very important to see this matter. So we mentioned again about the role of the habitual resident. Also become apparent in Article 4 of Rom 2, pursuant to which application of the law of the country in which the harm occurs is rejected in favor of the law of the place of habitual residence. when a person harm and a liable person both have their habitual residence in the same country. And similarly, Article 1, Article 2 of Proposal 1, Article 4 Proposal 1 BIS, which states the general rule on allocation on jurisdiction opt for a jurisdiction based on the principle of the dependent domicile. And the conflict between the principle of proximity and principle of legal certainty appear notably with respect to the rules determine the applicable law in absence of choice of law. In Regulation ROM 1 and 2, there are clauses that argue for closer connection to another country. So in ROM 1, Article 4 stated that where it is clear for all the circumstances of a case that contract is manifestly more closely connected with a country other than that indicated in the preceding paragraph. So it is the law of a country that applies here. The similar situation exists under regime ROM 2. In this regulation, this begins with a general conflict rule of Article 4 and continue through the most of the specific conflict rules for product liability, Article 5 unjust enrichment, and negotiation gesture, Article 11. All these articles provide for the possibility of derivation of the principal rule of connection when they are manifestly closer connection with another country. So, Regulation Proposal 1 BIS also offers flexibility in a particular case by authorizing as an exception for other than of the dependent domicile. This flexibility is, of course, intentional. As recital 16 of the preamble to the regulation demonstrate, so here we cite, in addition to the dependent's domicile, there should be alternative ground of jurisdiction based on a close connection between court and action, or in order to facilitate the sound administrative justice. The existence of a close connection should ensure legal certainty and avoid the possibility of the defendant being sued in court of a member state which he could not reasonably have foreseen. This is important, particularly in dispute concerning non-contractual obligation arising out of violation of privacy and rights relating to personality, include defamation. In area in which the contracting party do not have an equal status, or the regulation tend to assure an adequate protection of a weaker party. Article 6.2 of Regulation ROM concerning a consumer contract is an example. In this case, the choice of law is permitted. It cannot result in depriving the consumer of protection that assumed by the provision of law that would have been applicable in absence of choice, cannot be avoided by contract. And then the next example is protection is foreseen in Article 8, individual employment contract. A parallel to this concept is revealed within the regime of Proposal 1 BIS and its Article 17, jurisdiction concerning consumer contract, and Article 20, jurisdiction in individual employment contract. Another parallelism is also established between Article 7 of ROM, insurance contract, and related Article 10 of Proposal 1 BIS, jurisdiction in insurance matter. So, we can see many similarities between the Proposal 1 BIS, ROM 1 and ROM 2. So in Regulation ROM 1, the idea of protection of the weak party seems to less apparent. But recital 31 of the preamble to the regulation status to respect the principle of party autonomy and to enhance legal certainty, the party should be allowed to make the choice and to the law applicable to a non-contractual obligation. The choice should be expressed or demonstrated with reasonable certainty by circumstances of the case, where established the existence of the agreement. The court has to respect the intention of the party. Protection should be given to weaker party by imposing certain conditions on the choice. Additionally, Article 5, in case of product liability, Article 6, in case of contract competition, seem to follow the same line of reasoning. So here the structures of coherent. All three regulations are complementary and consistent in the scope of obligation. They form a homogeneous group of civil and commercial obligation, excluding the same matter from the scope of application, administrative and custom matter, family relation, bill of exchange, check, etc. The European legislators sought to introduce a parallel legal structure into the text of the three regulations. The general rule are followed, a specific rule concern particular contractual and non-contractual relationship, and accompanied by gap clauses. This logical order allows to increase comprehensive and transparency for everyone who call upon to apply the law. In all regulation, the parallelism and consistency of the main notion is kept. Same definition of habitual resident appear in Article 23 of Rome 2 and Article 19 of Rome 1, both for natural person and for legal entity. This example could be also cited as one of express diversion with respect to regulation Bruxelles 1 bis. On above conflict of law and regulation, only the place of central administration is important for the determination of the habitual resident of the legal person. The different situation appear in Article 63 of Bruxelles 1 bis, which propose three criteria of determination. Recital 7 and 24 of the preamble to Regulation Rome 1 express provide for a harmony between the text of this regulation in Bruxelles 1 as well as Recital 7 of the preamble to Regulation Rome 2. So that is the case. So we now go into some differences of three regulations to conclude our discussion today. So what are the differences? Why Rome 1 and 2 as act on a conflict of law essentially answer the question of applicable law. The Bruxelles 1 bis as an act of procedural law basically show the question of jurisdiction, mutual recognition, and enforcement of judgment. The objective of the law of conflict and those of the law of international civil procedure do not necessarily run in a parallel way. For instance, the principle of protecting defendant play a substantive role under Regulation Bruxelles 1 bis, while Regulation Rome 1 and 2 call for the applicability of the law most apt for the specific situation. While Bruxelles 1 bis assign the case to the authoritative power of state, or even directly specify the relevant court by regulating jurisdiction, Rome 1 and Rome 2 only decide on a matter question of the applicable law. And lastly, in contrast to Rome 1 and Rome 2, which in principle only call for the applicable law of the single jurisdiction, Bruxelles 1 bis provide the possibility to turn it forward. So that is all the matter about free regulation. And for the regulation Bruxelles 1 bis, we now go to some reform in the future. So we just give you some clue for some reform of the Bruxelles 1 bis, Bruxelles 1 bis. According to Article 79 of Regulation Bruxelles 1 bis, the EU Commission shall present a report on the application of Bruxelles 1 bis regulation by January 2022. This paper intends to open a discussion about the present state of affairs and necessary adjustment of the regulation. Although there is no need to change its basic structure, the relationship Brussels 1bis regulation with other EU instruments as the general data protection regulation should be reviewed. There is also need to address third-state relationship and cross-border collective redress. In addition, the paper addresses several inconsistencies within the present regulation evidenced by case law of NGHİ, such as the concept contract, Article 1, the place of damage, Article 7, the protection of privacy and concept of consumer, Article 17 and 19. Finally, some implementing procedural rules of EU member states should be harmonized on assessment of jurisdiction by the national court, on judicial communication, and on procedural time limit. Overall, the upcoming review of Brussels 1bis regulation opens up an opportunity to improve further a central and widely accepted instrument of the European law of civil procedure. So again, we just focus on some regulation of crucial, and hopefully we have some more discussion in the future. At the matter is very complicated to discuss. Thank you. Thank you. You are listening to the press review from National Institute of Intellectual Property by Professor HInguyễn U, presented November 2021. Thank you.